Welcome to IP Goes Pop, your source for exploring the interface between intellectual property and pop culture. The IP Goes Pop podcast series is created and produced by Volpe Koenig, an intellectual property law firm based in Philadelphia, Pennsylvania. Visit us at vklaw.com. This program should not be considered legal advice. Please consult an attorney for your specific situation. And now your host, intellectual property attorney, Michael Snyder.
Cheers, listeners, and welcome to IP Goes Pop. This episode, IP Goes Pop, is taking it to the streets, if you will, in an almost Doobie Brothers-like fashion to answer all your questions about IP urban legends. What is an IP urban legend? This is information that's circulating out there about patents or trademarks or copyrights or trade secrets. And it sounds right, but it isn't quite right. And certainly from a legal standpoint, it's probably not right. Now, joining me this week is my fellow shareholder with Volpe Koenig, Joseph Gushu. Joe practices primarily in the patent and licensing areas, but we've worked on many different projects in various areas of IP together. And most importantly, I should say, Joe is a student of popular culture with an encyclopedic knowledge of movies and TV, as well as other podcasts. So welcome, Joe.
Thanks for having me, Mike. Real happy to be here.
Now, what Joe and I have done for this episode is we've taken a survey of colleagues, friends, and family and collected some of their IP urban legends and some of their questions. And today we will try to set the record straight. Now, just as a background, a lot of times you will hear in a news report that someone got a trademark and it actually turns out they got a patent. Or you will hear that they copyrighted a word, but it'll turn out that they got a trademark. With that brief background, I want to jump in with Joe and talk about patents. So Joe, are you ready?
I'm ready, Mike. And as soon as I told someone I am an intellectual property attorney or that I was studying intellectual property law, you start getting some questions from people, usually formed by their touches in the space with pop culture, and they have some ideas about how things should work. And I have to correct their understanding pretty quickly and tell them it's really a patent or a trademark or a copyright, as such it is when it's brought up to us. And yes, Mike, I'm ready to get into patents because this is what I do spend most of my time on the day-to-day basis.
So I'm going to start these IP urban legends with a term I know that people have heard for a long time. And that term is patent pending. And it sounds very official, patent pending. Do you have an invention? Oh, I have patent pending. I'll give an example on the show Shark Tank. A lot of times the innovators that come on Shark Tank to have an investment in their idea, they'll ask a question. Usually one of the judges that wants to sound very smart will say, do you have a patent on this idea? And they will say, oh, well, I have patent pending. And then the judge will nod their head in a very satisfied fashion.
Yes. Patent pending, yes. Yeah, that is happens every Shark Tank, and that's a great first use of patents in pop culture and something I think a lot of listeners will have had experience with. And like I think you were leading into, patent pending really doesn't mean a whole lot when it's brought up to a patent attorney. You learn quite quickly that it is easy to have patent pending after most inventions. All it takes is for a person to file what's called a provisional application with the patent office, and then they're able to say that a patent is pending on it. Now, a provisional application is not a utility application, and you do not have any ability to prevent someone from taking that idea if you just have a provisional application.
So let me interrupt you right there, Joe, on provisional patent applications. If you could break it down exactly what that means. So let's say I'm an inventor. I come to you. You're a patent attorney. I say, I have this idea. Maybe I have a limited budget. What can you do for me?
Sure. when we have people in that similar situation come to us, what we want to ask them is how soon are they taking their invention out into the world, either telling someone about it, trying to sell it, um, anything about sharing their idea outside of their company or, just get it out in the open. And what they need to do, one of the requirements of patent law is that you are the first person to come up with that idea. And it's very important that you file and submit that idea with the patent office. That marks your date in time for your idea, which is very important with patent law and prevents anyone else from stealing your idea or attempting to get it on file at the patent office before you. With patent law now, the law has changed in that we are at first to file jurisdiction in the United States, which means you need to be the first person to file your idea with the patent office in order to have a patent. So if an inventor comes to me, I see how far along they are with their idea. It's very important that an inventor be able to capture all the different ways of doing their idea. The description of their idea is enabled. And at that point, we would have a pretty good document.
So the urban legend part of this that I want to clear up is when someone files let's say a provisional patent application, and they now have patent pending, can the inventor stop someone else? Can they use that? Can they block anyone? Do they actually have any rights now that they filed?
No, they don't have any rights. All the filing of a provisional application does is give them 1 year to decide whether they want to proceed with filing a non-provisional application. So they can write patent pending on there. They can attempt to get maybe some funding for their idea or some investments in their business. And at that point, they can make a decision whether they want to proceed with the more expensive non-provisional patent application and proceeding with that. And another thing to keep in mind when a lot of people on Shark Tank come on and they want to say patent pending, they're looking to get funding. Investors they want to know that there's a patent on different ideas and the idea won't be stolen, or there'll be some ability to license or get some money from someone with a similar idea. So that is really what is granted to someone that says there's a patent pending with a provisional. Of course, when you file a non-provisional application, that process takes a couple years in order to the non-provisional application to go through the whole process with the patent office, and then hopefully you wind up with a patent at the end of it. So that's a long process. And at that point, you can replace patent pending with a patent number.
So basically, you are not guaranteed a patent just because you are not guaranteed to get an issued patent just because you file a patent application. Is that right?
That's right. And that's usually one of the more important conversations we have with first-time inventors or companies, maybe with limited funding, and let them know that this is a expensive and long process. Depending on the idea, from writing up the case to actual issuance, it could be over upwards of $10,000 or so to go through that entire process and the years it usually takes in order to receive a patent.
All right. So just to summarize patent pending, it means you filed a patent application. It doesn't mean you have an issued patent, and you cannot yet use your patent application to stop someone else. But patent pending is really a placeholder, if you will, until you get an issued patent. So if someone believes in the urban legend that patent pending means they actually have some protectable rights, it does not mean that they have protectable rights just yet. So that summarizes the first IP urban legend today, which is patent pending. Now, this may be the holy grail of IP urban legends, which, by the way, the holy grail itself could be an urban legend.
Yeah.
We don't know.
We don't know.
So the whole topic might collapse in on itself, but here it is. And I think after that setup, it better be good. And I think it is. I think this is one a lot of people have heard. It's one of the number one IP urban legends. When we asked people about it, does mailing a letter to yourself give you any type of intellectual property protection? Just to set it up, a lot of times people have heard, well, I protected my idea, I put it in a sealed envelope, and I mailed it to myself. Now, of course, this is in the world of printed mail rather than electronic mail. I wonder if currently, if people think emailing themselves could do the same thing. So let's take it one step at a time. Joe, I put you on the spot. Does mailing something to yourself give you any type of intellectual property protection?
No, not that I'm aware of, Mike. I don't think that would really protect you in any way at all. And it's surprising to me how this idea got out there into the public, because everything with patent law needs to be done with the patent office, either the US or your foreign patent offices. That's another misconception that people have, is that if I file a US patent, that means I'm good everywhere, right? And the answer to that is no. Each country has its own patent law and own rules. So that's another reason why people and companies need to be very cautious and take a lot of consideration when deciding where they actually want to obtain patent protection for their ideas. Because with actually the time limits of filing cases, that's also critical. You need to make some very big decisions early on in the process, deciding what jurisdictions you actually want to seek protection in. But as for mailing anything to yourself and hoping to have any rights or to grant you anything, it does not.
Let me add a bit to that on outside of the patent field, and we're going to transition in a couple of questions to copyright. So let's say you type something up and you create a movie script, or you make a drawing, or you have a painting. Mailing that to yourself also doesn't add anything to your protection. You have copyrights as soon as, in the copyright law, we say as soon as you set it in a tangible medium. So as soon as you type up your movie script, as soon as you draw your drawing on a piece of paper or digitally in a computer and save it as a digital file, you have rights. So now I will say this from a litigation standpoint. In litigation, it is sometimes important to date when something was created. So this doesn't provide you any protection, but in a sense, the only way that the mailing it to yourself could be of any use is if you were trying to date a time certain when you created or conceived of something, and you could say, I have this sealed envelope, and you put it into the record in court, and you have to authenticate it. But it's a long way to go when, if you file the patent application, you have a public record of when you actually have conceived of or reduced your invention to practice. In copyrights, you can publish it, or you could file a copyright registration, and of course that would be dated. This really wouldn't work much for trademarks, which we'll also talk about. Trademarks have to be used in commerce with goods or services. Just sending yourself a letter is none of those things, so it wouldn't help for those as well. And to wrap up our patent urban legends, the last question that we received was an interesting one, and it's really about marking with the patent numbers. And the IP urban legend is, if you have a patent, and of course, when you get a patent, it gets issued with a patent number. If you don't mark a patented product with it, you lose your rights. So, Joe, if you could tell us a little bit about what is patent marking. I know it's part of the Patent Act. What is it, and what does it mean insofar as your rights to your patent or your rights to recovery under your patent?
Yeah, sure, Mike. I could touch a little bit on this. So my background's with more in the electrical space. So patent markings doesn't necessarily come into. It's not as prevalent as with some mechanical ideas and mechanical inventions. What is important is listing your patent with your product in order to provide people notice that there's a patent on it. So that is very important if you go to license or litigate your patents later. It provides a customer or another company the notice that there is a patent on this, and that they should be reaching out to you if they attempt to take any concepts or take your invention and use it in another manner. There are a number of different laws have been updated with virtual marking, which is basically updating and bringing this whole marking requirement forward into the 21st century, where there's websites and other repositories where companies can provide listings of their patents and how those patents are used in different devices. Again, all for providing notice to other companies. And this then provides the patent holder the ability to reach back and uh, try to obtain damages from anyone who may be stealing their ideas due to satisfying this marking requirement.
All right. So patent marking, you don't lose anything if you don't mark with the patent other than your right to recover damages, but you don't lose your invention. But the right to recover damages is actually a very valuable right. So if you have a patent and you're making a product under the patent, you should mark it or use what Joe said, which is virtual marking, which is you put the address of a website on the product directly. And then someone could go online and look up that web address, and it will take you to a website that will match the patent number with a particular product. So again, you don't have to mark, but if you're smart, I think you will. If there's no product to mark, of course, there's nothing to do, so you don't have to mark with the patents. We are certainly knocking out in this episode of IP Goes Pop some of these urban legends. Now, let's get to copyright, and it's another interesting one, and it was another one where we received the same question from multiple sources, and it had to do with copying songs. So to put it in context, there are certain ideas out there as part of this IP urban legend that you can copy a certain number of notes from a song. For example, someone said, well, I always thought that you could copy 5 notes from a song and that's fine. You don't have to worry about it. Or someone else said it was 10 notes. So certainly out there is this urban legend. And this implicates what we call in the law the doctrine of fair use. So under fair use, it actually is true under copyright law that in certain circumstances, and this gets very complicated legally, and we are not going to dive all the way down into the depths of fair use, but you can use limited portions of another work. For example, you could use sometime quotes if you're doing commentary or criticism, certainly in news reporting. But the question is, for the IP urban legend, is there some mathematical formula as to how much you could take in a safe manner? Joe, I put you on the spot again.
Whenever you ask a lawyer a definitive question like that, the answer is always, it depends. And as for saying whether 10 notes is too much or too little, again, I would just have to fall back to my lawyer answer and just say it depends. There's no clear-cut amount of borrowing too much, but what you would like to do is look at different cases, maybe find something similar to the song you wanted to borrow from and seeing if you felt comfortable with it. A lot of the issues that come up with copyright, at least in my experience, is if it becomes very successful, whatever you're coming up with, odds are, even if you think you were in the clear when you started, you likely aren't by the time you're very successful with what you have. So you probably will get into some legal trouble, or there will be some legal trouble that needs to get sorted out if you do copy some notes of a song.
I'll tell you, Joe, it depends is a perfect answer for fair use because it is an incredibly complicated area of the law that looks at. And by the way, thank you. That was a little teaser for a future episode of IP Goes Pop where we're going to focus on some recent popular music where different people and artists were accused of infringing and the outcomes of those. So that's a little bit of a teaser for a future episode of IP Goes Pop. But coming back to fair use and the analysis, so there are different factors we look at for fair use. One would be purpose and character of the use. That's whether it's a commercial use or an educational purpose. Of course, if you're going to use someone else's work to sell your own work, it's going to be looked at differently. You have to look at the nature of the copyrighted work or the work that someone's taking from. If it's highly original and they take even a little piece or part of it, in that particular case, that's going to be looked at with a certain amount of scrutiny. They also look at the amount of the work taken as a whole. But if you think about a song, you could have, for example, Queen's Bohemian Rhapsody is an over 8-minute song, but there are certain parts of it that are very easily recognized, and they're only maybe 10 or 11 notes long. If you took that from the song, that would be seen as a substantial taking because of how it's related to the song. And then the next factor under fair use is the effect on the potential market for the value of the copyrighted work. So if you take so much of a work that you kind of supplant the marketplace, then that's not going to be considered fair use. So this is a really there is no Joe said it perfectly. It depends. There is no mathematical formula. I'm really not sure where the mathematical formula came from, because I can envision a situation where if you're comparing songs where 5 notes takes the most important part of the song. And some, even if you think of commercial jingles, some jingles are only 3 notes long. So in that case, you're taking the entire song, if you will. So I think that it's again, very complicated, no easy answers. I will give you an example that should have been an easy one, which if anyone knows, again, Queen and David Bowie's Under Pressure, which
I had that list on my paper here. Yep.
which had a very recognizable bass line that you knew exactly what song it was as soon as you heard it. Along comes an artist, Vanilla Ice, and the music copies that particular bass line, but adds 1 note to it in a repeating fashion. And of course, that was not found to be fair use and resulted in many different adventures for Mr. Ice.
Oh, yeah. I remember that there's a very famous interview he gave. I think I've seen on VH1 Behind the Music, where he's very confident that the additional note made his song distinct from the Under Pressure. So,
and even though we are attorneys and we do often say it depends, I think that one we would say it didn't depend.
oh, yeah, I agree. I agree with you, Mike. And then most artists you'll see, every week, another artist is getting accused of borrowing too much. I think Katy Perry had it recently, Taylor Swift. Obviously, Led Zeppelin had a very famous case of this, and then the correct ownership of some songs. So you'll frequently see music in pop culture find its way into the IP space. Just if you make yourself a little more aware of it, it happens more often than you'd think.
So to summarize the IP urban legend, there really is no algorithm or mathematical formula. We urge everyone to be careful, of course, when taking or basing their work off another work. And you may, in fact, need to have a professional analysis done. Of course, the best course of action in music, as we're going to talk about on a future episode, is to just pay the royalty for the sample. But we'll leave that there for now. That's not part of the urban legend. Now, this urban legend relates to the Wild West of the internet, where copying is very prevalent. And in fact, at one point, I had advised someone that we now live in a cut and paste society, so you have to be very careful with the internet. So the IP urban legend is, if there's an image on the internet, let's say on social media, Instagram, Twitter, Facebook, then there's no copyright issue with copying that, since it's already out there being shared, and you can do whatever you want with that image. So let me get Joe's perspective on that as well.
Absolutely not. It's sad, but it's very easy to find things quickly on the internet. You want to, people come to us, I found this. I just want to incorporate this picture, use this picture, get it in my, materials, start marketing with it. And you really cannot do that. You need to be very, very careful about using any work that you did not come up with in anything, because you will likely be stepping on some people's intellectual property there. But there are a lot of resources out there for you where people have dedicated their creations, their art, their text, their software code to the public domain, and they've given creators the ability to use the material that they created, so long as it's attributed to those original creators. So there are things you can do, but absolutely not. You can't just be grabbing things off the internet and starting to use it just because it's there and free. Doesn't mean it's going to be free for you to use it.
I will say, in the context of social media, for example, on Facebook, if you're sharing a post, there are terms and conditions of Facebook, and there are times when that is allowed. There are other times when you might see your post taken down, or you might see the original post taken down. That's because someone with the copyright owner probably complained to have it taken down. Now, this segues into another IP urban legend, and the question we got was about the copyright symbol, and do you need to file a copyright registration to use the copyright symbol? And of course, by the copyright symbol, I mean the C in the circle symbol.
Yeah, you are able to use the copyright symbol as soon as you create something. It's just the act of registering your copyright with the patent office gives you some additional rights that you may need with your work.
So the C in the circle, anyone can put that on your website, put it on your work as you created, put the year that you created it. You don't need to do anything special. And legally, it doesn't really act as notice either. So you don't have to do it, but it is a good signal to say to the world, hey, I think this is my original creation, but you don't have to register it. I want to now go to trademarks. And there were some interesting trademark urban legends as well. I think because we're talking about symbols, let's start with the question was, as soon as I think I have a trademark, can I use the R in the circle symbol? So copyright, the answer was use the C in the circle to your heart's content. How about the trademark regime or the trademark world? What about the R in the circle? Joe?
The R in the circle is different than the C in the circle. So
First of all, just to interrupt, they're spelled different, which I think is a big difference.
So the R symbol is a federal registered trademark. That is a process where you take your mark, you indicate what it is being used for, and you submit an application to the Patent and Trademark Office where your mark is examined. It is a less complicated process and less time-consuming process than the patenting process, but still someone will look at the mark and the how you want to use it and will grant you the trademark to then use that. So the R is quite important that way. As something that is also comes out with trademark law, which goes back to some urban legends, is you can't just file for a trademark and not do anything with it. You can't sit on a trademark. So you actually have to register it and then start conducting business using that mark. You'll frequently hear after some big events like a Super Bowl or someone makes a silly commercial or some event happens, and you see a lot of people flooding the trademark office with different registrations for something related to it. Most of those applications for those marks won't go anywhere. But then one of the big hurdles is you actually have to be doing something with the mark. So that is something that's quite important. And that's why the R symbol's really important. When you have it, means you've been registered and you actually do need to be conducting some business using that mark.
And just to tie it into another part of pop culture, which is sports, Joe, you probably remember and have all the facts about the famous Philadelphia Eagles play on 4th and 26.
Freddie Mitchell, yes.
So the next day, there were at least 5 trademark applications in the trademark office for 4th and 26 for clothing items. So you're absolutely right. It is a race sometimes to the trademark office. So that clears up the urban legend of the trademark symbol. And I think one more point we'll hit on the IP urban legends is registering your company's name as a corporation gives you some kind of trademark rights. Joe touched on this a bit. That is absolutely not true. You do have to use it in commerce in providing your services. So if you have a company name, ABC Inc., you register it with the state of Pennsylvania or the state of Delaware or another state, you get your certificate of incorporation. It doesn't mean that your name is actually protected. So you would still have to protect it with a trademark filing. So that brings us, and we covered a lot of ground. I think we'll absolutely have to have Joe back to dig into some of these different intellectual property points. But Joe, thank you for navigating these IP urban legends with me. Any final thoughts?
No, thanks for having me on, Mike. I really appreciate it. I think we could do a really deep dive into any one of these topics. But hopefully everyone in the audience now has a better understanding of some of these terms when they come up. And hopefully, like as was the case this morning, my daughter's watching SpongeBob and someone tried to patent Krabby Patties. And I had to explain to her, now that really wasn't possible with that. So hopefully you're able to dispel some of these myths and just know that more of them are created on a seemingly daily basis. So it's always good to just know what the different big categories of patent law are so you can keep things straight and that so you can understand when something you see in a movie or TV show isn't accurate and you can act like a know-it-all to your friends and tell them, well, actually, no, that is a trademark, not a patent. So it was fun to get into these topics with you, Mike, and I really appreciate you having me on.
Oh, absolutely. So with that, dear listener, this is Michael Snyder from Volpe Koenig with IP Goes Pop. Watch out for those IP urban legends. Don't be fooled. And we will see you next episode.
The IP Goes Pop podcast series is created and produced by Volpe Koenig, an intellectual property law firm based in Philadelphia, Pennsylvania. Visit us at vklaw.com.